talk about 16B, and to that end, I would like to bring somebody up, called Alan Candy, who will talk about it in general terms because he has been subjected to 16B in relation to, he'll tell you, if he wants to. He'll tell you part of the story because you see this is being filmed. He can go to jail. If this gets out in the public, he can go to jail. I can go to jail for 3 months. And yet, all of this kind of stuff is secret, and anything that is unjust in any way has to be hidden. As with Stephen, but with Stevens, it got out. This guy over here, Paul, he's also going to come up and talk. What they're going to tell you about is what's being hidden, what's being kept from the public. Without further ado, would you give a warm welcome to Alan?
Thank you, Jim. I'm going to be doing some of this.
By the way, sorry, Alan, you've got 5 minutes.
5?
Yeah.
Oh, 5?
Yeah, 5.
Okay, well, it's going to be very quick then. I'm going to start by saying, ladies and gentlemen, during times of universal deceit, telling the truth becomes a revolutionary act. So, more or less, said Eric Arthur Blair, sometime before he died in 1950. Telling the truth is a risky business. That's why so few people do it. How many of you here know who Eric Arthur Blair was? One hand, two. George Orwell, indeed. The creator of the pseudonym George Orwell, most famous for his novels, satirical novels, Animal Farm in 1984. A great speaker of the truth, he especially knew the dangers of telling the truth, felt that telling the truth represented. We have a long history of the danger of telling the truth. Much earlier, almost 400 years before, Galileo Galilei discovered the risks associated with telling the truth. And 2,000 years before that, or before today, Jesus Christ himself found the same difficulty. And more recently, National MP Nick Smith was forcibly reminded of the dangers of telling the truth. Standing here before you today to talk about what I'd like to talk about, I face some of those same risks of persecution, punishment and penalty, simply for speaking the truth. So before I start, I'd like to say, first, this portion of the summit, this gathering here today, is private. What I'm about to say is also private. I'm not in the business of publishing, and this is not publication. And you can film it, but should anyone publish any of what is said here today, they must bear the burden of that responsibility. Secondly, I assert that what I'm saying here today is opinion. It may or may not be the truth. That is for you to decide. And whatever it is, it remains my opinion. And thirdly, I declare that what I say here today is said strictly in good faith, for the benefit of all, because I firmly and passionately believe that what is happening here in New Zealand, to which my talk relates, is wrong. It is blatantly wrong. Our government is wrong, and we must all take action. Indeed, we all have a duty to take action, to right these wrongs using all legal means at our disposal. So I'll begin my story. My son was born in March 1996. My name is recorded as his father on the birth certificate, but I was not married to his mother. This is a matter of public record. But privately, I never lived with the mother. In fact, our relationship ended the weekend he was conceived. To date, these last few facts are not in the public domain. They are, however, evidence in family court proceedings under the Guardianship Act 1968. Accordingly, under Section 27A of the Act and under Section 169 of the Family Proceedings Act, I am prohibited from publishing this information, and so are you. That's the letter of the law. And I make my point to demonstrate how ludicrous family law really is. and has been for the last 25 years, because I cannot publicly announce that I wasn't living with the mother of my son. And because I was neither married nor living with the mother at the time of the birth, under Section 6 of the Guardianship Act 1968, I was not legally a guardian of my own son, even though I am named on the birth certificate. And of course, I am considered liable to pay child support. But I didn't learn that I wasn't a legal guardian until about 3 years later, when allegations were made against me in the so-called family court. However, in the interim, I accepted that I was the father and proceeded to fulfil my role as if I was, maintaining contact with the mother, attending antenatal classes and attending the birth, and seeing my son about twice a week for the next 2.5 years. By that stage, my son was staying with me overnight almost every weekend, and he was in no doubt that I was his father.
Got 1 more minute.
1 minute.
Get on to the 16
Okay.
minute.
Well, that was part of the problem. My relationship was so good, so strong and positive, that every time I arrived to visit or collect him for the day, as soon as he knew I was there, he was standing behind the locked front door, putting on a little jig. Until his mother unlocked the door, I would hear the sounds of excited squealing and little feet stamping behind the door. As soon as the door opened, he would rush to my feet. He would stand there and thrust his arms up at me in a clear command. "Pick me up!" Being his obedient father, I did as ordered. He would then throw his arms around my neck and look at his mother with the biggest of grins on his face.
Your time's actually up.
He was very happy.
Very.
But guess what? Someone else was not. The mother began to feel threatened. Her relationship earned none of those displays of love and affection. When he returned home, there was no reciprocal performance. I was clearly his hero, and she was just his mother. But fortunately, we have the family court to help sort out these little problems. Yes, the family court. Let's call it what it is. The allegations court. Now, if you want me to stop there, I will.
I think that's good. Thank you very much, Alan.
Because I would like to go on to the Care of Children Act,
But
but perhaps we'll do that.
we can leave the rest of that to your imagination, because you know what happened next. There was an allegation against him, and he was... Okay, give him a clap. Right, next we have under 16B. You can say what you like, as you just heard. Also, you can take a protection order against a person, and that means that the child is also automatically on the protection order. Sometimes you can get special provisions in regard to access and all the rest of it, but for the most part the child is on the protection order, and therefore you've got problems around access and custody. The next speaker is Paul, and Paul has been through an almost unbelievable train of events in regard to a protection order. So welcome, Paul, and if you could just talk about the protection order. Thanks. Give him a clap.
Good afternoon, ladies and gentlemen. Now, under the same auspices that Alan gave you, I would require the same. Nothing I say in this forum can leave the room. Protection order. A protection order was ordered by the Waitakere Court against me in September of 2004. The order was based upon allegations which, as Jim said earlier, did not need to be refuted. It is just about an automatic rubber stamping down at the Waitakere Court that a protection order is issued. The protection order, would have seriously curtailed my access with my children. In my benefit, I had the backing of Child, Youth and Family Services because I was raising my niece. It would have been hypocritical for a judge to give me supervised access with my children, yet I'm an approved caregiver. of my niece from Child, Youth and Family Auspices. A protection order had been issued against me in September. In October, my ex-partner, her mother and the 17-year-old disgruntled son of mine came round to the house, invaded my house, attacked me. The police were called. The police arrested me. The police arrested my wife. I was taken down to Henderson. My niece was ripped out of my arms, screaming and shouting. Excuse me.
Just take your time. Good on you, mate. That's all right.
I now face criminal proceedings at the District Court for breach of a protection order and assault. My home was invaded. I was assaulted. I laid complaints with the police. My complaints have been largely ignored. In the Victims' Rights Act of 2002, there are certain rights an individual has as a victim. I was a victim. My wife was charged over the incident. The other two people hiding behind the protection order have not been charged. In the Victims' Rights Act of 2002, every condition that the police and the victim support should have extended to me have been breached. I am still being treated as a criminal. Under the auspices of the protection order, I have been punitively ordered to attend Man Alive, a re-education centre for men with anger problems. I do not have an anger problem. I have stipulated time and time again that I do not have an anger problem.
Paul, in the meantime, your children have been abducted, is that right?
Subsequent to all of these issues coming and hitting me from left to right, my children have now been the two youngest children have now been removed from New Zealand. They are currently either in the United Kingdom or Sweden. I'm still being hit for child support. There is a Hague Convention case going on. When will I see my children again? I do not know. After the assault and the incident in October, I attempted suicide. My suicide and emotional state precluded that I did not attend my first anger management session with Man Alive. I am being persecuted by the White Hat Greek Corps for the non-attendance of that. The persecution continues. I will remind people, for 21 years I was a loyal husband and a dedicated father. I had the unfortunate part was I married into a dysfunctional family. My eldest children are growing up dysfunctional. I learned of my 17-year-old son, the one who came into my house and attacked me. The other weekend he is driving around in a motor vehicle supplied by his maternal grandparents, intoxicated on a bottle of vodka, being aggressive to his older brother.
Okay.
These are none of the traits that I hold. These are the dysfunctionalities. I entered the relationship, I said enough was enough, and I have been persecuted. Let no man walk where I have walked.
Now you can see why I get hot under the collar, why I do demonstrations, why I go in front of judges' houses, why I go in front of lawyers' houses, called, in fact, some of these lawyers are called domestic violence factories. There is a huge domestic violence industry out in the West here. And as I've just shown to you, like the police are always targeting the men. And that's interesting because the very next speaker is in exactly the same boat. This guy is Steve. You would have seen him on the TV a few times. He again would be in a, you'd have to, excuse him if he's in an emotional state. What I want to talk about now is a Hague Convention case. What I want to talk about is the letter of the law versus the spirit of the law. The spirit of the law always says down in that Waitakere court or any other court that you go to, the best interest of the child. What a load of bullshit. These people, none of them are qualified in any way in any form of child development. None of them. Not at all. Alright? And these are the people, the counsel for the child, the lawyers and the judges that are making some kind of determination on the letter of the law, yes, she should go back to Wales, versus the spirit of the law, which is in the best interest of the child. Now, I'm not going to say any more because I'm going to leave that to Stephen. All of his details are out in the public. Publish! Publish and be damned. That's what he says. Come on, Stephen, give him a good clap, please.
I haven't sort of been able to give this as much time in the last few days as I hoped, so I'll just jot some things down this morning. Basically, so excuse me if I sort of ramble on. Basically, I might just quickly touch on a few points. As been out there on December, I was assaulted by my wife. I rang the police would come out to my house. They actually advised me to leave, and despite my pleas to them that I was going to be leaving a 5-month-old baby there with a very drunk, very violent woman at the time. There was some, over the next few days, my wife made false allegations to victim support, and the police and victim support, without even checking any facts, took my baby away from me, and I didn't even know where she was. Now eventually we went to a second court hearing down in the Waitakere District Court. The only new evidence in that hearing that day, which I got about 5 hours notice of and was not allowed to be in the hearing itself, was that my wife was actually being was remand on for the assault. That was the only new evidence. Now the judge that day overturned a previous judge's decision, and without even an application before him, made a custody order against me. And
Just say it as you memorise it. You know it off the top of your head.
Yeah, he made a custody order against me, and I tried to appeal that decision. This happened on Christmas Eve. Very first day the courts were open was 5th of January. I tried to get a stay in order so my child wouldn't be sent back to Wales. The family court judge that heard that appeal ruled that I was prejudicially late, and that without even reading the file, ruled that the other judge, who just to touch on a point that Jim made earlier about section 16B, the judge completely ignored his statutory obligations, or discretionary statutory obligations, completely ignored 16B in my case. And that judge that heard the appeal and stay, he just basically, without even looking at the files, ruled that the previous judge was a careful judge, so there couldn't be anything wrong. I was prejudicially late, and also put a warrant out to uplift my child, basically on the grounds that I had actually appealed. Because of that, I sort of had to. I did something against the law and abducted my child. While the principal family court judge came out in the press and put out details in the press, and then banned the press from saying anything else, that principal, Peter Bosher, he hadn't looked at the file either. He just merely went with everybody else and said that there's nothing wrong. He hadn't looked at the file. He didn't know that the previous judge had made an order without an application. He didn't know that judge, or if he did, he didn't mention it in his press reports that the previous judge had ignored section 16B in my case. No one told me about any rights to protection orders or anything. Victim support when they did find out they'd made a mistake, as well as the police eventually arrested my wife, no one came to me and took me to get a protection order. I'm still battling with victims of the court to get them to tell the truth about the story. So,
Stephen, did your wife have an alleged history of mental illness?
yes.
Yeah. A long one, a short one, do you know? Yes, long one. And did she assault you? Did she make a serious assault on you? And what was the result of that?
The result of what happened?
What did she actually damage on your body when she assaulted you?
Well, it was serious enough to perforate my ear. She just lost complete control that night. Was trying to bite my tongue out. Just bashing me around the head. It was a very scary thing in previous history with my wife, is that she can be very scary when she's been drinking.
Did she have to go on anger management at Manilove or anything like that?
No.
No? Oh, surprising, yeah.
No, nothing ever came of to her. The judge, the same judge that ruled on the custody hearing that went against me, actually sat on her criminal case at the courts and remanded her to a date to reappear on a date after she stated she was leaving New Zealand. In other words, knowing that she was going to be gone out of New Zealand, basically assisted her to leave the country without having to face the charges.
And that's happened subsequently as well? In the last few days?
Yes, after the decision on Monday regarding the Hague Convention, which went against me, the courts made sure that my wife had a notification that the order preventing removal of child from New Zealand was in my wife's hand Monday morning, so she could leave the country. I didn't get notification that that order had been lifted until Wednesday. They knew damn well she was going to leave the country.
They told her to, didn't they? Must have.
Like I say, she had a fax copy of that Monday morning. I never had my lawyers never got notification.
And they also lifted the CAPS order on Caitlin, is that right?
That's
Without consultation with you?
That's right, there was no consultation or any notification until the Wednesday, well after my baby was gone.
Okay. Thanks very much indeed, I appreciate that. Right, that's not all. You know, there's plenty more stuff where that came from. These are the cases that would be prepared to come today. They are risking, as you know, as they have told you, they're risking imprisonment, and so am I. Now, the other thing that happens under this new mediation system, which is sort of like the Aussie method, but without the Aussie outcome of shared parenting, is that for some reason men can't have, that's fathers who go into this mediation conference, can't have representation, can't have a support person, whereas the child has a support person, and whereas the mother has a lawyer, not a support person, a lawyer in both cases. I went in there as a support person twice and was refused by Peter Mather twice. I can name the cases. I've got one over here that you might be interested in. This is my, wrong way around. Still the wrong way around. It's always going to be the last one, isn't it?
Murphy's Law.
Yeah, Murphy's Law. Okay, now, again, you haven't seen the name over there. I faxed this to Judge Boshier from the family court to say that this guy had been denied access to legal help. So I've been in this court 71 times, so I can help them, and I can make suggestions which are mainly helpful suggestions. I don't go in there and be disrespectful or anything, because I'm not supposed to, and I don't. But what I do is help the guy. Now, he was refused access to me, even though I signed a form to be a Mackenzie friend and all the rest of it. Now, this is disgraceful. What is going on in this area, in this place is absolutely disgraceful. And, you know, let's just look at this concept of a domestic violence industry, because all of these people are making huge money out of family court stuff. Wrong way. No, I got it right this time. Just have a look at this, and then let's, obviously you can see that, I don't need to read all that out, but I think that defathered children are more likely to live in poverty, have trouble at school. This is Civitas research. Here it is. The Fatherless Family. A huge, huge research project in England. And we now have 235,000 children out of 1 million living in a different home from their father. It's going up and up every single day, and because of people like Peter Mather and the domestic violence industry out here, because of those sort of people, children are, as you heard, being denied access. Access, what a word. Isn't that when you go into a building, you get access to a building? They're being denied access to their children. All right, so we've got have trouble at school, have health problems. Not all kids are like this, obviously. Risk abuse of all kinds, run away from home, to become teenage parents, to offend, to smoke, to drink alcohol, to take drugs, to play truant, to be suspended from school, to leave school early, to attain no qualifications, and so on and on and on. Those negative outcomes of this court system occur. All you've got to do is change 16B and change it to the Aussie model and say, let's get on with making children the source of cooperation, not conflict. Because everybody's making a huge mint out of having conflict around children, they don't want to change it. All right? So, I'll be about 5. I'll finish at 12:30. All right. Okay. So, I haven't got through half of what I wanted to get through, but one thing I will say about the hypocrisy of all this, and this should be a good ending, I think. Okay, whatever. Yes, I've had it. Judge Duke came out when Peter Marnie resigned as principal family court judge, and Judge Bosher took over. 10-year-old access rules destroying child-parent relationship. But she is the biggest hypocrite in this world, because I have been in courtrooms, in 5-day hearings, in 2-day hearings with her, where she enthusiastically covers and deals with and encourages 16B access, 16B issues. She deliberately does it, and yet she's come out and said, this is all wrong. What a hypocrite. The system is a hypocrite. The system is saying, yes, we're going to get fathers back into the family, and they're doing nothing about it because there is no will to do it, except some stupid old coot in front of the family court in Waitakere in a bus with a PA system telling him what he thinks of it. Sorry, that's it. That's it.